I just handed these out, and I mentioned this the last week, but it was a thin group. I went into Staples to get these printed, which from a point of view of cost was the best decision, but I needed them the next day. And so there was a young guy in there that was handling the printing. And so after he produced these, he asked me, he says, "You're a lawyer, can I ask you some questions?" And this is a classic example of why I think you need personal lawyer, general practice lawyer, to deal with whatever business or family issues you had. He said he'd gone online and used a fairly well-known website to start forming an LLC. And he wanted to know if that made sense. I said, yes, a good idea. I said, corporations are a little more complex, LLCs are easier. And he was very proud of the fact that he formed the LLC in Delaware. Why he would form it in Delaware, I don't know. We're talking about a one-person operation. Then he said, should I also register with the Secretary of State? He said they want me, they say I should do these things. And they said, well, some of them you probably do. You do need to register with the Secretary of State. I said, now, you may not want to do that, but you could go online and do it for about $15 to $25 yourself. But because the LLC is in Delaware, he also has to register as an out-of-state entity that's doing business in the state of California, which will cost him some extra money too. And the website he went to had a list of items that they thought he needed. And he said, I don't know if I need to do this. Should I pay for it? And I said, well, look, you're just beginning your business. What's the business? He says, it's an internet business, social media. And so what I told him to do is I said, look, go make a list. And next time I come in, I'll go through this with you and tell you whether you need to do this. You need to do 1, 4, and 6. You can do 2, 3, and 5 yourself. And then you can make a decision. But the point is, since last time I heard Tanisha mention the fact you don't know what you don't know, that's absolutely true. If you're someone who's starting a business and you haven't had background in that, then there's a lot of things you don't know about. I just handed out what was going to be my PowerPoint presentation, and I'm getting there. I call them slides. But the first one's the vision statement, where I talked about what it is I do and the fact that I want you to be your primary care lawyer. The second you've seen before, it's this person in the maze saying help. And that's the young man at Staples. He needs help to figure out which way to go and what to do. But it's also when I start trying to either do a trust for someone, a will for someone, incorporate a business for someone, I'm in the same position. I don't know what it is they need until I start talking to them. Basically probe, like a salesperson who's selling something, whatever it is going to do some fact finding to find out what it is the customer needs. And websites don't generally do that. Now you might be able on some of them to actually pay extra and talk to a lawyer who's God knows where. At least he has to be in the United States, but nonetheless, you don't really know who you're talking to. The questions you ask are what's important. I mentioned recently a probate that I was handling for a woman who had a long-term companion, then they got separated, he died, they were never married, she has 2 minor children. And that's a cautionary tale I've been using to talk about because she's essentially a legal stranger to that estate. And on the 29th, I got her appointed as the administrator for the estate without a bond, but then everything she does, actually I do, has to be approved by the court. There's $45,000 that came out of the house that we're foreclosed on. That goes into a blocked account. There's Fidelity stock or bonds, which we're not sure what it's worth. The court's going to have to, we're going to have to go to the court and say, okay, we want to either liquidate these or leave them until the kids are 18. We don't know. One of the questions I asked her was, what about you? Do you have a will or an estate? Do you have trust? She has 2 minor children. The only relative she has is an older son by another marriage who's 23. Now, maybe she's got an aunt or an uncle. Let's assume hypothetically she's got an aunt or an uncle or a parent. Unless there's a document like a will that says who is going to be guardian of those 2 minor children, it's going to be a free-for-all. The court will decide. It's not necessarily the closest relative. The court's going to have to decide, okay, who is the appropriate person? And that means somebody is going to have to go to court and ask to be appointed guardian. Now, if you're doing a will or a trust, even if you don't have real estate, and it seems like a small estate, people need to think about, okay, who's going to be the guardian of my children, plus who's going to handle the money? It may be 2 different people. I have a friend who, in his trust, if his wife dies before he does, and then he dies, then they both agreed that his brother was going to be the guardian of the children. But he said, we also both agreed, and she has her own separate will and makes a different decision, but in his brother's not going to handle the money for the children that's left in the estate, because he said, my brother doesn't know how to handle money. So he's designated the person who's going to be the trustee to handle the money to be a friend who's very financially sophisticated. Those sorts of decisions need to be made, and I guarantee you, if you go to the internet and do a will, nobody's going to ask you about it. There's 100 questions I can ask people about their family background that makes a difference. Not one size doesn't fit all. People will come to me and say, well, what's a typical will or a typical trust cost? And I have an idea of what that would be, but the fact is, it's going to be custom unless it's just, something very unusual. So I have one of the slides says, why not internet will or trust? You don't know what you don't know. You don't know all the legal options that you have. I don't know until I talk to you and question you and spend time asking you what you want to do and telling you what you can do before you get a proper will or trust or contract or incorporate your business, have an operating agreement. The young man from Staples that gets the LLC, in the state of California, you can have an oral operating agreement for an LLC. Now, as Louis Mayer said, at Metro Go to Mayer, he said, an oral contract isn't worth the paper it's not written on. It leaves you totally without any options. Assuming you start an LLC, you get married, you have a partner. It's not just a one-person LLC. What happens when you die? Maybe the wife doesn't want to run the business. Maybe she does. Maybe she or he doesn't get along with the partner. So there needs to be a buy-sell agreement. What happens with the membership interest or the stock if it's a corporation? Those are things that you only find out by knowing what the person's background is and what they want to do. Next, I have a quote from Felix Frankfurter, and he did not invent the hot dog. Justice Frankfurter was appointed to the Supreme Court by Roosevelt, actually. But this sort of sounds, to some extent, to be sort of sophisticated, and you think, well, what's this really about? The Supreme Court. All our work, our whole life, is a matter of semantics. because words are the tools with which we work, the material out of which laws are made, out of which the Constitution was written. Everything depends on our understanding of them. That's particularly true in the law. To give you an example, legal decisions. In the last, on December 22nd, the California Supreme Court issued a decision called Augustus versus ABM Security Systems. And about 4 years ago, the California Supreme Court had issued an opinion in Brinker Restaurants, which dealt with wage and hour law, and it dealt with breaks. And if you read Brinker, it was dealing with restaurants and servers. And most people's interpretation of what Brinker said was that if a server doesn't want to take a break, as long as the employer permitted the break, made it available, didn't discourage it, then the employee had a right to skip the break, and the employer was required by law to insist that the person take a 10-minute break in the afternoon, unlike with meal periods. Well, on December 22nd, an opinion comes out from the California Supreme Court, basically the same justices, different context. It was the security company, and the security company required their security guards to be on call at all times, including breaks. And not surprisingly, the California Supreme Court said, no, you can't do that. You give somebody a 10-minute break, that 10-minute break means they don't have to work. It means they're free from your control. But that seemed like a logical conclusion. Then the Supreme Court goes on to start talking about, well, there's options. You can allow these people to take 10-minute breaks later. And by the time you read the decision, you're thinking to yourself, does this contradict Brinker from 4 years ago, and it's the same court? And so a lot of lawyers, employment lawyers, are saying, we're not quite sure where this leaves us on break periods. And I'm handling a wage and hour case now, and if you don't allow somebody their 10-minute break, and when I say allow, in the UPS case, they supposedly allowed their drivers meal and rest periods. But the schedule was so intense for the UPS drivers, the court said, you're not giving these people realistic time. You're expecting them to do their job, and they can't do their job and take a meal in the break period. Mm-hmm. So now this has all become ambiguous, and we're talking about judges who write decisions. Interpretation of documents. In the state of California, and the point of my handling of wage and hours, because it's 1 hour. If you don't give someone a 10-minute break, it's a 1 hour penalty. So if they missed 5 breaks during the week, they've got 5 hours of time. And if you go back 4 years, and remember, how many employers track break times? Nobody, hardly anybody. There's some new apps now actually which do that. So employers probably started doing that. In the state of California, there's exemptions for overtime employees. If you're an administrative, an executive, or a professional, you're exempt from overtime and meals, your salary. And part of the criteria for executive in federal law is that your primary time is spent doing exempt work. So they look and see whether or not this individual is primarily spending their time on exempt work. Okay. What does primary mean? In California state law specifically says that means 50% or more, but that's not how the feds interpret it. It may be 49%. Plus, the way the regulations read in the feds is that what the employee is doing is making is making judgments, decisions and judgments. And in California law, it says independent judgment. There's cases that say judgment means different than independent judgment. Both of them say discretion. The magic words are discretion and judgment in federal law, and it's discretion and independent judgment in state law. And if you're in the state of California, the employer's got to comply with both federal and state law, and they don't always match. In fact, sometimes in what they call wage orders in the different industries, the state law says that the federal law doesn't apply here. Other times it says refer to federal law. The point of all that is words do matter, which is what Frankfurter was talking about here. That's true in trust. That's why people talk about boilerplate in contracts. The reason there's boilerplate in contracts isn't to save the lawyer time, really. It does, but the reality is all of those paragraphs that are called boilerplate, those have been paragraphs in some case that the court said this is what it means. And so lawyers know if I put this in and it talks about applying California law or this law of the state where the document's entered into, that's what it means, because some courts said, yeah, that's what it means. The custom parts of the contract are something the lawyer's got to artfully draft. You'll find that in some of the, probably the next to the last. I talk about contracts. That's true of marital agreements, wills, trust, and as I say, legal decisions, court cases, and documents and regulations all can be subject to interpretation. So finally, I just kind of left with some rules. I collect quotations over the years. And oral contract's not worth the paper it's not written on. You have to have everything in writing. If it's not in writing, it's not enforceable. And here's a quote to make you pause. H.L. Mencken was a humorist from the 30s and 40s. His definition of a courtroom was a place where Jesus Christ and Judas Iscariot are equals. And that's true. You know, the courts, you all start out, no matter who you are, at the same level, and the lawyers manufacture the cases. Einstein's 3 rules, I just thought this was interesting for us as a group. Doesn't particularly relate to the law. Einstein's 3 rules of work. Out of clutter, find simplicity. From discord, find harmony. And in the midst of difficulty lies opportunity. Thank you for your attention. Questions?